These charges outline the gravity of what the court is now facing. The allegations span years, involve multiple counts, and carry consequences that could permanently change a life. Counts 1 through 4 are charges of rape. These are felonies that carry very serious penalties, from 15 years to life in prison or even life without parole. They also require Tier 3 sex offender registration. Counts 5 through 9 are gross sexual imposition. These charges carry a presumption of prison time, ranging from 12 to 60 months, and require Tier 2 sex offender registration. Counts 10 through 17 involve the illegal use of a minor in nudity-oriented material. These are second-degree felonies with possible sentences of 2 to 8 years in prison and Tier 2 registration. Count 18 is corrupting another person with drugs, also a second-degree felony, with a sentencing range of 2 to 8 years. Counts 19 and 20 involve charges of endangering children.
Count 19 is felony 2 that carries 2 to 8 year range. Count 20 is a felony 3 that's 12 to 60 month range. Count 21 and 23, sexual conduct with an animal. Misdemeanor 2, jail term is the max of 90 days, maximum fine is $750. Counts 22 and 24, same charge. Misdemeanor 2, jail term of 90 days and maximum fine of $750. Is your client ready to enter a plea?
She is, Judge. Her plea will be guilty. I'm sorry, not guilty.
Okay. So you've waived reading of the indictment. Anything from the state?
Yes, Your Honor. Our request is a $1 million bond based on the allegations which are currently before the court. The court already obviously knows that the defendant is facing the potential of life without parole on 4 different counts of this particular indictment. That gives the state concern about the defendant's continued appearance in court on these matters. Also, the state continues to be worried about the public, specifically the individual child victim that makes up several of the counts of this particular indictment involving this defendant. We would ask that in addition to that, there be electronic monitoring house arrest if she were to make any such bond, that there be a no contact order issued with regard to all minor children as well as animals, and that there be a order of protection with regard to the 5-year-old minor victim of this particular offense.
Let me just say, first of all, Ms. Grove, you're presumed innocent of the charges that I've just informed you you're facing. You have a right to have a trial, entitled to have a trial by a judge or a jury of 12 people.
You have the right to confront any witnesses who testify against you. Your attorney has the right to challenge every witness. You also have the right to request witnesses and have them ordered to appear and testify on your behalf. You have the right against self-incrimination. That means you do not have to prove anything, you do not have to present evidence, and you do not have to testify. If you choose not to testify, that decision cannot be held against you.
On bond.
Yes, Judge. Thank you again. Erica's plea is not guilty today, Judge. Erica is in fact a victim here. She herself is a victim of her ex-boyfriend, Tony McAllister, and she never, ever has sexually abused her daughter. In fact, Judge, in this investigation, or at least during the investigation, her parents were advised by investigators that Erica was coerced to a certain extent, was largely coerced to do some of the things that she's now been indicted for doing. And in support of the concerns regarding her daughter Cora and the allegations of physical sexual abuse, Erica took and passed both a polygraph test and an eye detect test to show that she has never physically, sexually assaulted her daughter. Those results were provided to the investigators, and I assume those results were also provided to the prosecutor's office. We've seen some media reports, I believe coming from the prosecutor's office, discussing text messages referring to conduct. And Your Honor, just to address those conversations or those posts referred to by the government, there are going to be graphic text messages, I believe. I've not seen them. They're alleged to be evidence in support of some of the physical sexual abuse allegations. And what the court is going to hear is that oftentimes those messages were attempts to cope with a very difficult situation, being a victim as she was, and or to placate her abuser, again, Mr. McAllister, because she never sexually assaulted her daughter. Erica has absolutely no criminal history. She lives here in this community. I will say, in response to the prosecutor's admonitions as it relates to Cora, she had sole custody of her daughter. I know that CPS removed her daughter.
Her daughter now lives with her father. Erica understands that she is not allowed to have any contact with her daughter during this case. She lives in the community and owns a home here. She has surrendered her passport to the court, and it is available for the judge to hold. She is a licensed nurse anesthetist in Ohio and has voluntarily placed her license on inactive status. She has known about this investigation for some time.
The investigation initially started about mid-December. She was charged with the misdemeanor offense December 23rd, and in early January there was a CAC, and she was advised by investigators of the nature of their intention to charge her with physical sexual abuse charges. And despite all that, she's never left the jurisdiction, Judge. In fact, what she did is she retained counsel, and she has been preparing for her defense ever since. By way of background, I will tell you that she is a graduate of the Medical University of South Carolina. She graduated in May of 2008. She graduated summa cum laude. She then began her military training in 2010 with the United States Army. Between 2010 and 2013, she was stationed at Tripler Army Medical Center in Honolulu, Hawaii, and she provided direct patient care and a mixed medical served on the mixed medical surgical ICU. Then, still in the military between 2011 and 2012, she was stationed in the Philippines as a critical care flight nurse. As the flight nurse, she provided stabilization care to combat trauma casualties during Operation Enduring Freedom. Still in the military between 2013 and 2016, she was stationed with the 47th Combat Support Hospital at Joint Base in Lewis McChord, Washington, where she was the head nurse for what they call a rapidly deployable combat support hospital and ICU. Between 2016 and 2019, she was stationed at Bethesda, Maryland, at the Walter Reed National Military Medical Hospital, where she was a clinical staff nurse in the surgical intensive care unit. And in this role, she was also selected to serve in the White House Medical Unit, providing critical care and non-critical care to both the first and second families. And between 2019 and 2020, while stationed at Walter Reed National Military Medical Center, she was promoted to assistant head nurse of the surgical intensive care unit. And Judge, I can confirm for the court, because I have seen and reviewed her DD 214.
When she retired from the military in May of 2020, her rank at honorable discharge was major. During her military service, she received multiple commendations, including the Meritorious Service Medal, the Joint Service Achievement Medal, the Army Achievement Medal, the Joint Meritorious Unit Award, the Army Good Conduct Medal, the National Defense Service Medal, and the Global War on Terrorism Expeditionary Medal.
In about 2021, after retiring from the military, she transitioned into the private sector. She wanted to be close to her parents who live in Northeast Ohio, and also with her... Judge, I apologize. Again, she wanted to be close to her parents who live in Northeast Ohio, but also she wanted to be close to her brother and his family. They live in Southeast Ohio. She She actually bought a home here in Warren County so that she could be close to family. She also began work, again, as a nurse anesthetist at Bethesda North Hospital, where she was very well received, very well respected by both her peers and doctors. Regarding bond, I heard what the prosecutor just asked the court. We're taking a little bit different position. But we'd ask the court to consider not just our comments, but her history, her background, educational, military, professional, the fact that she doesn't have any criminal history, the fact that she hasn't left the jurisdiction even knowing that these charges were coming. We'd ask the court to balance her as a person and her background against these horrible, horrible charges and agree to set a bond that is at least achievable. We'd ask the court to consider a bond, and we know that it'll come with conditions as it relates to no contact orders involving Cora and whomever else the court deems appropriate. We also would expect any bond to include electronic monitoring, but I don't think that she can achieve $1 million bond. We would ask the court to consider a bond of $250,000 at 10%. I wish I could say that she would use her home, but I don't think her home is valued at more than $300,000, and she has a note on the home. But that's what we'd ask the court to consider for purpose of bond setting.
All right, thank you.
As the case moves forward, the court must weigh the charges, the rights of the accused, and the evidence that will ultimately determine the outcome.